Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. I'd like to welcome you to this morning's webinar where we're going to be talking about basics of the Sunshine Act. A couple preliminary issues to get out of the way first. If this is the first time you've participated in one of these webinars, basically it is a PowerPoint presentation with me speaking in the background. If you have a desire for the PowerPoint, you can find it on the OOR's website under the training tab, and just scroll down to the main training tab and you'll find all of the PowerPoints that we use for these training sessions. Feel free to download them at your convenience and use them, for your own personal reference or maybe local training, whatever your needs are. The session is also being recorded, and occasionally we will get requests for copies of these recordings. You can contact our office, and usually what they'll do is send you a link to file sharing, and they'll upload the recording, and then you can access it that way. If for some chance, like your IT security or just limits of your system, you can't use that functionality, then what you can try doing is send in a flash drive with a self-addressed stamped return envelope and a note indicating which recording you'd like, and someone will make a copy of that recording and mail it back to you. We still do that as well. Questions. During this session, if you do have questions, you can type them in the meeting chat feature. And as I'm going through, I'll do my best to answer your questions, live as they occur. But I have, two requests. First is that, we're talking about the Sunshine Act. So, let's keep your questions on point, open meetings, and, that particular area. The second is that you try to keep your questions fairly brief and on point. It's just awkward for me to sit here and sometimes have to read through several paragraphs while everyone is patiently waiting. If it looks like your question is specific to your particular situation or unusually complex, we'll do one of two things. We'll wait until the end of the presentation and I'll come back to it. Sorry about that, and answer it for the good of everybody who can stick around for the hour, or we'll take the conversation offline. I'll ask you to reach out to the office, call in. There is administrative staff who are well-versed on the laws and they can help us out, or they may forward the message to someone higher up the food chain, maybe even me, and we'll have that conversation and do our best to get you steered in the right direction, okay? So all those things out of the way, I think we can just jump right into the presentation. Give me just a second. Yeah, we're good. Okay, basics of the Sunshine Act. Why is this important? Well, first off, the Sunshine Act is also commonly referred to as Pennsylvania's Open Meetings Law. And I like to begin this presentation. I'm not going to read the whole thing, somewhat paraphrasing, but this is taken right out of the, what I'll call the preamble to the law. The purpose of the Open Meetings Law is due to the right of the public to be present at all meetings of agencies to witness the deliberation, policy formulation, and decision-making of those agencies. And this is vital for the functioning of a democratic process. And we want to emphasize that secrecy in public affairs undermines the faith of the public in their government and the public's effectiveness in fulfilling its role in a democratic society. Okay, very high level sounding stuff there, extremely esoteric, but I think it's important to go back and review this periodically, because having open meetings may not be comfortable at times. It may get ugly, it may be inconvenient at best, but it is the fundamental precept of a democratic society that government be open and that the public be aware of what decisions are being made and how they are being made. Now, I like to think that looking at the Sunshine Law that there are three basic precepts that need to be addressed. You know, when people call in, whether they be a member of the public or a member of an agency, they will ask, you know, well, was this meeting legal? There are three things that I begin the conversation with looking at. First is that there needs to be advance notice to the public that the meeting is occurring. And we're going to, you know, go over these requirements that exist within the Act. And then how do you attend? Because in recent years, in addition to the live component of a meeting, more and more agencies are adopting social media and other electronic means that allow members of the public to witness the deliberations and the decision making that are going on from the comfort of their home computer. Uh, the public has a right to observe the deliberations, and we'll talk about, you know, what deliberation means. And then they also have the right to comment prior to the agencies making any decisions. And when I use the term agency, that's in a very generic sense. It could be, you know, a state agency, commission, board, whatever government entity it might be, as well as local government in Pennsylvania, cities, boroughs, townships, school districts, public authorities, public boards, public commissions, any form of local government where there is deliberation and decision making taking place. Occasionally, we will get questions, well, what about homeowners associations? They do not qualify as government entities, okay? Those are dictated by private contracts, by private covenants, and a homeowners association is not considered a government entity, and therefore their meetings are not subject to the Sunshine Act. But just about every other government entity is, and these precepts apply. Okay, so let's begin by talking about, you know, continuing the discussion, who is covered. You know, the Sunshine Act applies to any state or local government body and all committees. Okay, you notice committees is italicized there. The reason is that quite often questions come up, is our committee subject to the Sunshine Act? Well, let's take a look at the act itself and under the definition of, you know, an agency in the act. So yeah, any state or local government body and all committees that perform an essential government function. Okay, the definition kind of builds on itself. Okay, so what is an essential government function? It's somewhat subjective, but let's talk about that. Okay, I'll give you a quick example here. Let's say that we are a township and the local girls softball team has won the state championship. Okay, a tremendous accomplishment. And we've decided that we need to celebrate this. So we're going to have a parade. We're going to have some sort of, you know, maybe a community cookout or something like that, and recognize the significant accomplishment. So we're going to appoint a committee, all right, and they're going to be responsible for arranging everything, you know, to make sure that the parade and the cookout go off okay. Well, as important as this accomplishment is, I think that you could argue that it is not an essential government function, okay? Um, it just, you're not going to find anything in law that says you must celebrate, you must recognize the accomplishments of the local girls softball team, okay? Good to have, but not necessarily an essential government function. Now, we could change it up a little bit, and let's say that this committee is responsible for periodically reviewing all of our ordinances, all of our dictates, all of our policies to ensure that, number one, they're not in conflict with any other laws, that the language is up to date, and the law itself is relevant, et cetera, et cetera. Okay, it turns out there are statutes that dictate that this must be done. And it is a standing committee appointed by the board. You know, there, I think you could argue that it is an essential government function that all of our ordinances be relevant and up to date. So that committee, more or less, when it meets, would probably be subject to the Sunshine Act, that those meetings must be open. Then we come up to the next standard. And remember, this builds upon itself. Exercises authority to take official action. Okay, the committee has to have some meat to it, something that it truly does. And then we're up against, okay, what does it mean, take official action? Well, it turns out if you look at the Sunshine Act, go to the definition section, there is a definition of official action. And part of that definition is making recommendations. So that's the part of the definition that I want to emphasize. And by the way, let me go off script a little bit here. Whenever you're attempting to understand a law or an ordinance, I strongly recommend do not ignore the definition section, because if in the language of the act itself you find some ambiguity, you find some stuff that, does this conflict with what I just read or my understanding? What exactly does this language mean? A lot of times you can find the answers in the definition section. So we've looked at the definition of an agency. Now we're looking at the definition of official action. That official action includes the term making recommendations. So if you have a committee that's performing an essential government function, that's exercising authority to take official action, and that official action may be that we're making recommendations back to the main board, then that committee more or less would be subject to the Sunshine Act, and its meetings must be open to the public. Now you're thinking, well, why would you have a committee that isn't taking official action? You'd be surprised. Quite often there might be a committee that's appointed simply to go out and research an issue. Okay, don't come back to us with the recommendation, simply come back to us with information and the board will figure it out. Okay, we'll make our own decisions. We'll make our own recommendations on how to proceed with a course of action. And then, unfortunately, the reality of politics is that occasionally an issue will come up where the board doesn't really want to deal with it. So the solution is, well, let's appoint a committee and then the problem will go away. All right, that'll satisfy the people who are bringing this issue to our attention. We'll just appoint a committee and hope that nothing happens. All right, that happens more than we like to realize, that we appoint committees that really have no authority. Chances are that those information gathering committees would not be subject to the Sunshine Act because there's no real result to the mission that they've been tasked with. It's simply go look at the problem and, hopefully it'll go away. All right, so that is kind of how we look at whether or not a committee is covered by the Sunshine Act when we limit our research to the act itself. Now, what about case law? Because with any law you have, chances are someone has litigated issues related to provisions within that law, and the Sunshine Act is no different. Now, there's not a lot of case law related to the Sunshine Act, but there is some related to bigger issues. And I will say that in recent years, I think it started with COVID and how public meetings were being handled. Also, I think people are paying more attention to the deliberations of their governments at the local level. So we have seen more court activity related to the Sunshine Act in recent years. But still, there's not a large body of case law with the Sunshine Act like there is with the Right to Know law. So we have to rely on what we've got. So again, we'll come into this answering this question, who is covered, but this time looking at case law. And there is a decision out there. It's called Wristow versus Casey. Casey is Governor Robert Casey from several administrations ago. And essentially, the governor appointed a committee to take a look at some appointments that were being made. And this case, Wristow, someone felt it was inappropriate and whether or not they should be covered, so we have this case law, Wristow versus Casey, that went up to the Pennsylvania Supreme Court. Okay, question has popped up. Would a safety committee with various employees who approve minutes every month then be subject to the Sunshine Law? Well, I think you've got to take a look at the standards that we're talking about here. What does the safety committee do? Are they in fact approving or making recommendations that would be considered an essential government function? Oftentimes, safety rules are dictated by statute. However, if it's purely involving the activities of employees within the government agency that don't particularly have an impact on the public itself, I would venture to guess that the safety committee is not subject to the Sunshine Act, because they're not necessarily making changes that have an impact on public policy. And pay attention to this slide, okay, Molly? I think you're probably just a little bit ahead of me. It's a great question, but I think this slide will answer your questions. Okay, first thing we have to answer. These are the questions that the court addresses in Wristow. Does the committee have decision-making authority? Meaning, are they in fact making decisions that they've been tasked with by the main board? Then we have to answer the question, are the members appointed by the board, and are they authorized to act on its behalf? Okay, now you're thinking, why wouldn't a committee be appointed by the board? Occasionally you will run across a committee that is what I call self-perpetuating. A public library might be a good example, where, okay, the board by statute has to appoint a committee to oversee the public library, but they don't want to have to, consistently appoint new members. So what they'll say is, if there's a vacancy on the library board, the rest of the board members are responsible for going out and filling the vacancy. Okay, find somebody within the borough, within the township, within the county, who can then serve on the board. Okay, we don't want to be bothered by it. You guys go ahead and take care of it. Okay, there the board is self-appointing. The members are not appointed by the governmental board for the jurisdiction. Okay, and then Molly, here's the point that I'm getting at, and this is probably the most important one that's brought out by Wristow. Are the recommendations pursuant to statute, ordinance, regulatory authority, whereby the result is the enactment of laws, policies, or regulations? Okay, safety committee is not going to, its decisions are not going to result in any statutory changes. So that's why I would tend to argue that the safety committee would not be subject to the Sunshine Law. Let's go back to the example that I was using with the softball team. Okay, the arrangement of the celebration, the parade, the cookout, whatever, okay, is not based on law. Okay, that's simply the community recognizing what the softball team has done. You're not going to find an ordinance or a statute anywhere that says if the girls softball team wins the state championship, you have to have a parade. Okay, that's why that ad hoc committee would not be subject to the Sunshine Act. Okay, if you can ultimately turn around and find or make that nexus between the mission of the committee and statute, local ordinance, whatever, and the result of that committee's deliberations are recommendations to changes in laws, policies, or regulations, then it would rise to the standard of the committee being subject to the Sunshine Act. Now, all of this, okay, is as clear as mud. I admit that, all right? And sometimes you're going to read the Sunshine Act, you're going to read these court decisions, and you're still not going to be sure, because there's all these iterations of government entities that may or may not be subject to the act. So what we say, and obviously this is going to be the position of the Office of Open Records because we're all about transparency, is that if in doubt, open up the meeting to the public. All right. And there's a very pragmatic reason for doing this. It may be inconvenient. It may be uncomfortable to have the public present and commenting and so forth. Maybe you don't like it. But the alternative, if you decide to close your meeting, is what I call the straight face test. Okay, you have a closed meeting, someone decides this is wrong, it's in violation of the act. So what they'll do is file a complaint with the local court of common pleas, and you end up standing before a judge explaining with a straight face why you closed the meeting and didn't adhere to the Sunshine Act. Now, if you can do that with a straight face, maybe the judge will agree. But if not, it can get pretty painful. Okay. And we'll explain what the sanctions are for violating the Sunshine Act here towards the end of the presentation. But my position is just from a practical perspective, it's better to open up your meeting rather than take the chance of having your meeting closed and being called into court. Okay, another question popped up. Softball parade example. If funding is expended for that event, does that affect whether or not the organizing committee is subject to the Sunshine Act? No, it does not, Melissa. Okay, good question. But just like with the right to know law, because an organization or an entity is receiving government function or funding, does not have any impact on its applicability to the Sunshine Act or the right to know law for that fact. Okay, you could have a 501c3 that receives a government grant, but if you look at the function, the mission of that 501c3, it really is not performing a government function in any way. All right, it's simply receiving government funds because they want a grant or low interest loan or whatever. That has no bearing on whether or not the deliberations of that organization. Like I said, great question. Moving on here. Okay, is it a meeting? Okay, because periodically someone will email us or call in and they'll say, I saw the township supervisors having breakfast together the other day. Isn't that a violation of the law? Well, no, it's not. Okay, they can get together and talk about the weather, trade pictures about their grandkids. Just get together and socialize whenever they want. They can meet as a group at that softball celebration, as long as they're not discussing government business, the business of the township, the business of the borough, the business of the district. Okay, they can still gather. All right, so there are some questions. And again, we go to the Sunshine Act definition section, and sure enough, there's a definition of a meeting. All right, well, first offhand, is there a quorum? Okay, if there's 5 supervisors, you got to have 3 of them together to make any decisions. Otherwise, they cannot legally conduct business. So if there's not a quorum of the board, then the gathering would not be considered a meeting. Now, what about when you're having an official meeting, you don't have a quorum physically present? Can other members phone in order to affect a quorum, to reach that quorum? Well, yes and no. Okay, under Pennsylvania law, if you go to the acts that govern the various government entities, you can phone in unless you're a borough or a first-class township. Okay, they, under the codes, require that a quorum be physically present. Now, what if, though, you're not a first-class township, or what if you have a quorum? Okay, the way it works is that the additional members can phone in, but there must be direct communication, meaning everyone can hear the person who's phoning in, and that person who's phoning in can hear everybody else. Basically, you can use a conference call, you can use Skype, Teams, Zoom, whatever your functionality allows. But what you can't have is someone sitting there, with a cell phone up to their ear, relaying what Fred is saying and relaying to Fred what other people are saying. It's got to be on speakerphone so everyone can hear them. Okay, so that's how that would work. Now, the next question we have to answer is there deliberation? And this is what I was getting at with the breakfast example. Are they talking about the business of the government entity, the jurisdiction? Okay, if all they're talking about is the weather and, how things are going downtown or whatever, that's not government business, and they are allowed to gather and have those conversations. But if they are talking about business before the board, then that would be considered deliberation, and the gathering could possibly represent a violation of the act. Then we have to answer the question, is there decision making? Decision making is, for our purposes, a vote. Are they making decisions by fiat that we are going to proceed in this manner regarding this issue before the board? Okay. If there's decision making taking place outside of the public eye, meaning outside of the provisions of the Sunshine Act, then chances are that is a violation of the act. Unless, and there's always a caveat, okay, it's of an administrative level. Okay, and this is kind of, we would go back to that safety committee issue, okay? Chances are the decision for purposes of the public was that we're going to have a safety committee, okay? And the board approves that and moves on. Okay, now questions come up about, well, what about how the safety committee meets? Who's going to serve on the committee? And what about the issues that the safety committee is dealing with? Okay, they are of an administrative nature. The board already voted on the policy level issue. We're going to have a safety committee. How the safety committee operates, those are administrative questions. And yes, the board can deliberate and make decisions on that level of decision making because it is of an administrative level, not of a policy level. And, be careful because this is also subjective. What is administrative versus what is policy? If it's administrative, chances are you can go back to a prior board decision that dictates how you will administer whatever is going on. Another quick example. The board decides they're going to buy a new truck, okay? That's approved at the public meeting, okay? What color that truck is going to be is of an administrative nature, and they can deal with that, through phone calls, through emails, et cetera, et cetera. All right. And then finally, I want to put down beware of email meetings. Okay. This usually comes up at the beginning of the business year where maybe you have new board members being seated. Perhaps the chair is from a business background and they want to make things more efficient. So let's just deal with this by email. Well, emails are not public per se, okay? I can't see your emails as the conversations are taking place. So if you are deliberating by having a conversation using emails, you are violating the Sunshine Act. Those deliberations must take place in a public setting. So be very careful. And, I would say if in doubt, don't do it. All right, your deliberations must take place in the public eye. Don't have conversations about policy level issues by exchanging emails or text messages or any sort of electronic communications. Okay, you're going to violate the act and find yourselves in trouble. Okay, well, what is not a meeting? Well, I hinted at this. Administrative action versus agency business. Okay, I think I've covered that. Work sessions. Okay, what is a work session versus a meeting? Well, I think school districts are probably the best example of this, school boards, where they'll have a monthly business meeting, where they have deliberation, they have decision making. It is open to the public. Okay, but then they'll also have monthly work sessions. Work sessions are held for educational purposes. It is a gathering of the board where um, like the superintendent or principals or assistant superintendents and all the staff people that they have will make presentations to the board on ongoing projects, on matters of import that the board wants to be educated on so that they can make informed decisions at the business meetings. The communication is limited, okay? The superintendent can brief the board on what's going on. As a superintendent, I can turn around and ask, or I'm sorry, as a school board member, I can turn around and ask the superintendent questions for clarification, but I cannot then turn to my fellow school board members and discuss the merits of the issue, because as soon as I do that, that's deliberation. Okay, so that's why it's for educational purposes. I can be educated as a public official, but I cannot deliberate that amongst the other public officials that are there representing the board as I am. Okay, and that would extend to conferences, board retreats, and the like. Okay, it's okay to have these gatherings. There's nothing wrong with that, but we cannot deliberate about public business when we're at these gatherings. Okay, so communication is one way, no deliberation, and obviously no decision making, no votes taking place. All right, so let's go now to the public notice provisions of the Sunshine Act, because as we said at the beginning, public meetings need to be announced in advance. And the way it usually occurs is that at the beginning of the business year, whether it be a calendar year, which is usually the case, or sometimes the fiscal year, starts July 1st, whatever, it's really, in some instances, it's at the discretion of the board. In other instances, it's dictated by code. Where at the beginning of your business year, usually there's an organizational meeting. Okay, well, at least 3 days in advance of that organizational meeting, there needs to be notification in a legal, it is a legal notice in a paid newspaper of general circulation that you're having the organizational meeting. Okay, and it needs to dictate, where the meeting is occurring, the time, and so forth. Newspaper articles, what the industry calls puff pieces, where maybe they'll interview the new board members who are being seated, cannot count. Okay, it needs to be a legal notice. Websites, having a notice on your website, while that is a good thing, and I encourage you to do it, it doesn't satisfy the provision of the law. It must be that paid newspaper. In those sales circulars that fill up our mailboxes several times a week, they don't count either. It must be a paid newspaper of general circulation for the jurisdiction. Okay, now I realize that this is becoming more and more difficult as we see structural changes taking place in the news media industry. But until the law is changed, this is what we must follow. So you need to account for those newspapers that are no longer daily. Maybe they've gone down to 3 days a week or whatever. Make sure that you account for that when you're submitting the ads, the paperwork for the ads that need to occur. And remember that those ads need to be published at least 3 days. I should probably say not ads, but the legal notices need to be published at least 3 days in advance of when the meeting is going to occur. If you miss that deadline, whether through a fault of your own or maybe a fault of the paper, you need to reschedule, okay? But this is the requirement of the Act. Now, what about special meetings? Oh, question has popped up real quick. Does this mean that we have to publish the recurring bi-monthly meetings if they have been published in an annual publication? I'm not sure what you mean by annual publication. If the annual publication is a paid newspaper of general circulation, then you'll be okay. I think what you're asking is that if we have bi-monthly meetings, do we have to do it every other month? The answer is no. If in your initial legal notice for the organizational meeting, you also publish the dates of all the meetings that are to occur in the coming year, that satisfies the Sunshine Act. And yeah, I probably should have said that. I'm glad you asked this. So let's say you meet on the first Tuesday of the month. Well, then you would say all subsequent meetings of the board will occur on these particular dates. You go through the calendar and you publish those dates. Now, let's say if at the organizational meeting, it comes to light that there's a conflict that, due to work schedules or other obligations, you can't meet on the first Tuesday. You're going to meet on the second Tuesday. Well, then you need to publish a second legal notice indicating the change in dates. Okay, we're now going to meet on the second Tuesday of the month, and these are the dates. Okay, hopefully that answers your question, and thank you for bringing that up. I should have covered that. Okay, now what about special meetings? Okay, and these would involve issues that, for whatever reason, they cannot wait until the next regular meeting, whether it's next month, next quarter, or whatever. Something's come up, maybe it's a grant application, maybe it's, how we need to expend funds due to a deadline or banking or whatever. We need to meet before the next regular meeting. Well, the Sunshine Act allows you to have a special meeting. And this would be, a full business meeting of the board, but because it does not occur on the regular schedule, you now need to have that legal notice, but you only need to account for 24 hours advance notice. Okay. And I should emphasize that if there is an online component to this meeting, the legal notice needs to say that there is an online presence in the meeting, and this is how you log in. Okay, this is the link to get you into the meeting, whether it be, a link to Teams, link to Skype, Zoom, or whatever. Okay, this is how you access the public meeting. And then the Sunshine Act allows for emergency meetings, and these are where, you have a bona fide emergency, the board needs to make a decision, and it cannot wait for a special meeting or the next regularly scheduled meeting. I used a snowplow example. We have an old snowplow in our borough. It's on its last legs. It broke down. We can't get parts, and the forecast is saying we're going to have a storm tomorrow. Now, down the way, there's a dealership with a snowplow on the lot. We can go buy that now, and we need it. This is a bona fide emergency. Okay, so the Sunshine Act allows the board to deliberate and decide to buy the snowplow because of the emergency situation. Okay, but beware, because you cannot create your own emergency in order to avoid having an open meeting. And again, we go back to what I call the straight face test. All right, if you find yourself standing in front of a judge explaining why you held an emergency meeting when the facts of the case are somewhat suspect, beware, because if the judge doesn't agree with you, it could get painful. Okay, and then there is no notification if you have to cancel a regular business meeting or a special meeting or whatever. But I would recommend that you use your social media to get the word out there that you are canceling the meeting because you can't find a quorum, or someone's sick, they can't make it that night or whatever. All right, because what happens is that people will log in, or they'll get in their car and drive down to the township building or borough hall, and it's crickets. Lights are out, doors are locked. It's like, what's going on? Because no one bothered to notify the public that the meeting is being canceled. that upsets people, okay? And for the little bit of time it takes, to use your Facebook page, use your website, whatever, to get the word out that we're canceling the meeting, you could save yourself a bunch of headaches. So while there's no legal requirement, you should be doing this. Okay, notice I'm saying should, not shall. All right, agendas. This is, I used to say this is new. This came up 2020? Yeah, I think 2020, August 29th, 2020. It could be 2019 now. Gosh, I'm getting old, I forget. But it is a newer provision to the Sunshine Act that we're now required to have agendas published in advance of the actual public meeting. So it basically says all agencies must post an agenda of issues to be deliberated on or planned official action. Okay, official action is a vote at least 24 hours prior to the public meeting. Okay, so that way people know what is going to be discussed and possibly decided at the meeting before the meeting actually occurs so that they can decide whether or not they want to attend or whether or not they feel they should attend. Okay, this includes regularly scheduled meetings as well as those special meetings that the excuse me, the entity may in fact decide to hold. Okay, it wouldn't include those work sessions or conferences or executive sessions, which I'll talk about here in a couple minutes. All right, so how detailed do these agendas need to be? Well, I would say look at it from the perspective of the public. Okay, what would a reasonable person need to know in order to make an informed decision about what the board is going to be discussing? So if all you put down is new business, that's not enough, okay? I can't make an informed decision that this is what you're going to talk about. All right. And I would say it is reasonable to argue that you need to give me more information. So, the board is going to be discussing and possibly deciding whether or not we're going to approve the construction of the new warehouse down on Route 6 on township property. All right. That is enough information for me to know I need to be there. So be aware of cryptic language in your agenda if the public doesn't know what you're going to be talking about. Okay, if you have a website, the agenda needs to be posted on the website. Now I have an asterisk there because many government entities won't have a website, but they'll communicate with the public using a Facebook page. Okay, well then the language would apply to the Facebook page. If you have both, well, maybe it's just the website, although it's just as easy to update your Facebook page along with your website with the agenda. And most government entities will do that. Then the agenda also needs to be posted at the meeting site, the business office, and you need to have copies of the agenda at the meeting to distribute to the public so that they can follow along. All right, so what about the timeline? Okay, and this confuses a lot of people, but it's really not that hard to understand. It's just, one of those laws that's written, maybe a little more vague than what we'd like to see. But you go through it and it does make sense. First offhand, prior to 24 hours before the meeting, it's fair game. You can change the agenda as you see fit. Okay, but now we've approached the 24-hour threshold. We're in that window, 24 hours before the actual meeting. You can only change the agenda for what we would call de minimis items, where number one, there's no expenditure of funds that are going to take place, and you're not entering into any contract. Okay, so minimal changes to the agenda. Now, the meeting is called to order and you have the agenda in place. Can we change it during the meeting? Yes, you can, but certain conditions need to be met. First, if an item comes up that's initiated by the public, during public comment or for whatever, the board has discretion whether or not they want to change the agenda or not. They can defer, to another meeting in the future and follow the agenda provisions as they see fit. But if it's initiated by the board, then number one, it needs to be by majority vote. Okay, the chairman can't just stand up and say, we need to change the agenda because. Rather, there needs to be, you need to follow whatever rules of order you have and say, we need to change the agenda to include this new item. Okay, so they can vote on it. And because it's a vote, it becomes a matter of public record and is included in the minutes for that public meeting. And then the chairperson needs to announce to the public why they are amending the agenda. And it's, so we can deliberate about the new warehouse that they want to put in down on Route 6. So they vote and they approve amending the agenda, and that now allows them to discuss the warehouse project. Okay, and that may result in a separate vote, or it may not. Okay, you can vote to amend the agenda so we can talk about the warehouse, and ultimately no decision takes place whatsoever. But at least it's in the minutes that we amended the agenda and had a discussion about the warehouse, even though we didn't make any decisions on it. But if we do make a decision, then that also falls under the provisions where we have to vote. And anytime you vote, there's a motion, a second, discussion, and public comment, which we'll talk about here in a moment. Okay, and then we vote, and that becomes a matter of public record, memorialized in the minutes of the meeting. Okay, now if we change the agenda, then the amended agenda must be posted on the website, on the Facebook page, at the meeting site within 24 hours after the public meeting has adjourned. And that begs the question, well, how long does the posting need to stay up? We don't know. The Sunshine Act doesn't address that. But this is George's logic, okay? And George is nobody. And it's possible that a judge may disagree with George. But until that happens, this is my advice. Since there is a 24-hour window prior to the public meeting, I think that there's probably a 24-hour window after the public meeting. So you post the agenda, the amended agenda, within 24 hours after the meeting has adjourned, and you have to keep up that agenda or keep the agenda up a minimum of 24 hours after it's been posted, okay? You're not going to find that anywhere in the Sunshine Act, folks, but the question comes up periodically. That's what I say. If I'm wrong, take that with a grain of salt. But I think that's probably the best guidance we can provide at this point. And remember that the minutes of the meeting, which is the official public record, have to reflect the changes to the agenda that may have taken place. Okay, public comment. I mentioned this earlier. In an open meeting where the Sunshine Act is applied, the public, meaning residents and taxpayers, have the right to comment on any issue prior to a decision being made on that issue that's before the board. Okay, now limited to residents and taxpayers. Occasionally you will get someone coming in from, the adjacent township or borough or whatever, and they sign up for public comment. Well, the board can deny them the opportunity to comment, okay, because of this language in the board. Then the Act says, right to comment on issues that are or may be before those pertinent. Okay. The problematic word in there is may, because that kind of opens it up. Okay, now ideally, the people are going to comment on what the board is discussing. But legally, a person can come in and complain about the potholes on their street prior to the board taking a vote on the warehouse, okay, because of that language that's in there. Now, there is the provision in the Sunshine Act that allows the board to establish reasonable rules for public comment. Okay, typically, we use this to refer to time limits. Everybody's going to get 3 minutes, okay, in their public comment period. Well, it can also apply to how you control comments being on point. And there's a solution for this that I'm going to talk about here in a moment. Now, time limits, okay, it could be 3 minutes, it could be 5 minutes or whatever. Usually what will happen is the board will pass a resolution saying that during our public meetings, we're going to allow 3 minutes. Okay, well, what about if something really important comes up, like this warehouse that everybody's interested in? Well, first offhand, you could say, well, tonight, we're going to set the rules aside and allow everybody to speak for 5 minutes to make sure that all your points are made. Okay, you can do that. There is flexibility in how you run your meetings where you're not limited by law to 3 minutes, okay? You can make it 5 minutes simply by following your rules of order, whichever, rules you follow. Let's say that you're going to vote on the warehouse and a big group comes in and they're all wearing the same t-shirts and they all sign up for public. Well, there's a good chance you're going to hear a lot of the same stuff over and over. So the chairperson, because of this provision within the Sunshine Act, they approach the group and they say, look, would you be agreeable to appointing a spokesperson so that we're not here all night? The spokesperson will make sure everybody's points get talked about, and we'll give them an extra 5 minutes, okay, to make sure that everybody's issues are raised here tonight. Would you be agreeable to that? And everybody says, well, yeah, that sounds reasonable, so we'll have a spokesperson. Okay, you can do that, okay? There's flexibility in this provision as long as it's reasonable and it's not being used to silence people. And then you have what we'll call specific versus general comment periods. Okay, this, you're not going to find it in the Sunshine Act, but rather it is what we'll call a best practice. I think I have it mapped out on the next slide. Nope. Okay, let me talk about it. There are a number of municipalities who have adopted this practice because it works for them. They will have a specific comment period, meaning prior to the board taking a vote, they will solicit public comment on the issue that's being voted on only. And then at the end of the night, they will have a general comment period where, yeah, the guy can complain about the potholes on his street. Okay, and that's, the subject matter is wide open. What I would caution you against is any attempt to limit the subject of public comment because it may not be relevant to the issue before the board, okay? There's a school district down in the Philadelphia area that got themselves into trouble over that. And there's, a backstory. It gets more complicated, but the simple fact is that a federal court decided that they were abridging that person's First Amendment rights by not allowing them do public comment during the public meeting. Okay, had they allowed the person to speak about the general issues during a general comment period, I think they would have gotten around that. Okay, now, question has come up. Am I correct that public comment, specific versus general, is only required at the local level, but not at state government agency? It's not required at any level, okay? Specific versus general comment, you're not going to find anything in the Sunshine Act that speaks to this. It is merely a practice that has been adopted by certain government entities that it just makes the meeting flow better. It's like, okay, we're going to have public comment, but please limit your comments to the matter at hand, what we're getting ready to vote on. If you have other issues that you want to comment on, we're going to have a general comment period at the end of the meeting itself. And I'm paraphrasing there, but that's pretty much how it works. Multiple comment periods during the public meeting rather than just one comment period. The Sunshine Act does apply to state agencies. So, okay, you're clarifying, is public comment required at the state agency level? Yes, it is. If that gathering, if that meeting is subject to the Sunshine Act, then you must accommodate public comment on matters of deliberation and general issues that that board may be, in fact, subject to. Okay, hopefully that addresses your question. Okay, so like I said, specific versus general, it's purely a best practice. It's not a requirement of the law. Okay, executive sessions. Periodically, the board will gather to discuss sensitive issues. They can deliberate on those sensitive issues without the public being present, okay? However, the public must be aware of the fact that the executive session is taking place or has taken place. Okay, so you can hold an executive session immediately before, during, or after the open meeting, or you can announce it for some future time that the board will be meeting in executive session. When you make the announcement, you must give a complete reason as to why you are having the executive session. And you're going to find a court case, Reading, City of Reading versus the Reading Eagle, where it was the practice of the chairperson of the city to announce we're going into executive session for personnel reasons or for legal reasons. The Reading Eagle, which is the local newspaper, said, well, that's not good enough. So they filed suit, and the court agreed with the newspaper. And there's language in this decision, but basically what it comes down to, and I'll paraphrase, is that because you are meeting in private, you are basically taking the public trust away from the public. So you must give them sufficient reason to agree that the reason you're meeting outside of the public eye is legitimate. So for instance, rather than saying we're meeting for personnel reasons, we are meeting in executive session to discuss possible discipline against one of our employees for a work rules violation, okay? Or we are meeting to discuss legal issues related to this particular court case. Here's the docket number where, you know, someone is suing us, all right? That way, the member of the public can go to the court, look at the docket number, and see that, in fact, there is a court filing against the township, against the city, whatever. Now, for an executive session, there's no requirement that minutes be kept. And if you do keep minutes, they are exempt from disclosure under Pennsylvania right to know law. A board cannot take official action during an executive session. Any official action must be taken when the board reconvenes in open session. So let's say that they gather to discuss possible discipline against an employee. They can discuss the merits of it. They can kind of decide amongst themselves that, yes, we believe a 3-day suspension is warranted. However, in order to consummate that suspension, it must take place in the open meeting. So they come out of executive session, reconvene in open session, and then entertain a motion and vote on whether or not to sanction that employee. Okay, that makes it official. Hopefully that makes sense. Okay, reasons for executive session. Like I said, personnel matters, which would include hiring, firing, discipline. This must relate to a specific employee or a specific position. Anything related to personnel policy, like pay issues, leave issues, benefits discussion, okay, of a general nature, that would not apply to an executive session. Only specific positions, specific employees. Discussing labor negotiations. What's the board's strategy going to be? You can discuss that in executive session. Considering purchasing, leasing, or selling a property. The law does not use the term selling, but there is an unpublished Commonwealth Court decision where the court says it's okay to discuss property that we want to sell in executive session. Consulting with counsel about litigation, court cases, violating privilege. Okay, privilege would be discussions of a sensitive nature with your solicitor. Okay, you can do that outside of the public eye. Discussing university admission standards. I wasn't around in 1950 when the law was written, but it's in there. Discussing emergency preparedness. Okay, this relates to Homeland Security. What is the evacuation plan for the county 911 center if we get a bomb threat? Some stuff like that, okay? You can discuss that in executive session. All right. Violations. I kind of hinted at this early. What if someone takes you to court? They think that you have violated the Sunshine Act. Well, they can, number one, I was getting ahead of myself. During the actual meeting, the public has the right to stand up and bring it to the board's attention. I think you're violating the Sunshine Act here. Okay, then they sit down and the board would then decide, or the chairperson or whatever, you know what? I think you're right. I think, we did something here that was out of the order of typical business. Maybe we forgot to allow public comment. So the board now can decide to cure the violation, meaning they can go back and say, we're now going to allow public comment, and then we'll re-vote, okay, to ensure adherence to the provisions of the act. Okay, no harm, no foul sort of thing. However, if they disagree and say, no, you're full of baloney, we didn't violate the act, we're going to proceed as we are, that member of the public or whoever can file a complaint within 30 days of the alleged violation with the court. If it's a local agency, it's the County Court of Common Pleas. If it's a state agency, it goes to the Pennsylvania Commonwealth Court. Possibly if they believe there's some criminal culpability taking place here, they can also approach the district attorney. The district attorney can investigate and render decisions related to criminal violation, but the judge, the court, is still responsible for rendering a decision as to a possible civil violation of the Sunshine Act. Okay, and usually what they'll do is they'll have a hearing. The parties will make their arguments. You'll have that straight face test that I earlier alluded to. And the judge has fairly wide leeway in what they can do if they believe a violation has occurred. Okay, they can simply slap the agency on the wrist and say, don't do it again. Or they can void a vote. They can void an entire meeting. Or if they believe that the violation is particularly egregious, they can levy a fine. And the fine is not against the agency. The fines are against the individual public officials. And it can be up to $1,000 for the first violation, up to $2,000 for the second violation. Paid out of pocket. The agency cannot pay the fine on behalf of the public official. So you see why I say it gets pretty painful. Now, I don't want to mislead you. This has not happened a lot. It's not common for a judge to levy monetary fines, but it has happened. What we've seen with this increase in court activity is judges really thinking outside the box And one of the things that we've seen is they require that the public officials go through training on the Sunshine Act. And it could be, going to a private attorney who's, maybe a transparency attorney. It could be going through one of the advocacy groups like the Boroughs Association or the township supervisors, or we've had instances where the judge said you had to come to the Office of Open Records and receive training on the Sunshine Act. And then we will send an attestation to the judge saying that these public officials have now been trained. And there's been other things that the courts have done that really address the issue at hand, which was that there wasn't intent to violate the act. It's just that the officials didn't know, okay, or the solicitor provided bad advice, stuff like that. All right, we're seeing more and more of it. Okay, but be aware of potential sanctions. All right, just some miscellaneous stuff for the good of the order before we wrap things up. Like I said, all public meetings must have meeting minutes that memorialize what public officials were there, what came up for vote, how was it voted on, and if there is a roll call vote, then the minutes must reflect the individual votes of each member. The public can record public meetings unannounced, meaning I can set my cell phone on record, put it in my pocket, come into the public meeting, and I'm not violating the Sunshine Act or Pennsylvania's wiretap law. You cannot demand that I announce that I'm recording the meeting, and you cannot prevent me from recording the meeting. Otherwise, you might get in trouble. All right. What I recommend is at the beginning of the meeting, when the chairperson is, making the announcements, the welcome and so forth, that they should include that there is no expectation of privacy in a public meeting and that it's possible this meeting is being recorded by a member of the public. Many municipalities will record their own meetings for purposes of keeping the minutes. Maybe they're live streaming it, okay, or maybe they will put the copy of the recording on their website. Okay, they should announce to the public that they're doing that. And by the way, that recording is considered a public record subject to access under Pennsylvania's right to know law until such time that the recording no longer exists. Okay, they are public records. Okay, so we are at the end of the presentation. If you have any further questions, now's the time to get them in before we conclude here. But in the meantime, I would like to encourage you to take a look at the Office of Open Records website. Okay, lots of good information on there. There is a page dedicated to the Sunshine Act with some FAQs. You can download the act itself and take a look at it. If you have further questions, contact the office. There are email addresses or phone numbers that you can use to call in with your questions. If the administrative staff can't answer it right there, they will refer you to an attorney who will get back to you usually within 24 hours to try and help you out. Now, we cannot provide you with legal opinions, okay? But we can guide you towards any court cases that may be on point, or the solution may be you have to file suit yourself, okay? But we will help you out as best as we can within our legal mandates, okay? So I want to thank you for your participation today. We had some good questions. It tells me, people are on their game here with the sort of things that they're asking, and that there is at least a foundational level of education when it comes to this act. It's important because, like I said at the beginning, that, it's a fundamental precept of democracy that the public has a right to know what its government is up to and has a say in what decisions are being made. So again, thank you. We'll be back again in 2 weeks with another webinar. Enjoy this nice weather that we're having, and stay safe, everybody. Take care.